they join. So welcome everybody. Thank you for joining today. I hope everybody's having a good midday, a good lunchtime. So the nature of the presentation today, we're calling it I've Got Investors, Now What, Part 2. So if you joined last week, our colleagues kind of led a discussion on some of the terms that go into the term sheet that's negotiated with venture capital investors throughout the course of a venture capital financing. Today, we're going to kind of pick up from where they left off and talk about what really the terms in the term sheet mean, what those look like for creating legal documents and contracts with venture capital investors through the course of a financing round, and then also go into what the role of a lawyer is in kind of this whole thing. So my name is Ben Kalman. I'm a student advocate at the Startup Law Clinic, and I'll let my co-presenters introduce themselves.
So my name is Ashley Perry, and I'm also a student advocate at the BU Startup Clinic.
And hi, everyone. My name is Steve Fleury, and I am also a student advocate with the clinic. And
in addition to the three of us, we also have Jim Wheaton on the call, who is our supervising attorney and the director of the clinic here at BU. So one quick housekeeping message. So we do encourage you all to ask questions, and it would be great if you could put those in the chat. Because it's just the three of us, we're not going to be actively monitoring the chat during the presentation, but we will leave time for Q&A at the end, and we'll return to any questions that are put in the chat. So feel free to do that. Just know that we're going to come back to them towards the end of the presentation. So, all right. All right. So the format of today's flow. We're going to, again, set some basic assumptions and then talk about some of the key deal documents that go into a venture capital financing, and then walk through a little bit of a very basic securities law primer, and then talk through due diligence. And we'll explain what that looks like and what that means towards the end. So some basic assumptions before we get going. First of all, this presentation itself is not legal advice, right? Legal advice is a specific term of art that requires you engaging with a lawyer and talking about the specifics of your individual situation, your case, and having that lawyer agree to represent you as legal counsel. But what this is a general review of kind of what it looks like to go through a venture capital financing round, generally speaking, with professional venture capital firms as investors, to have an idea of setting the stage a bit for what to expect during those rounds. And one kind of a core basic assumption for this presentation. So, obviously, if you all have your own business entities, you know that the form companies can take. So the form of business entity can vary in a lot of ways. And there's a couple of different variations and flavors on business entity. However, the core assumption for this presentation is that we're talking about a venture capital financing round for a corporation that is incorporated in Delaware. And if that sets off a red flag, hey, I have an LLC, something like that, feel free to ask at the end. But don't worry. It's not wrong if you have an LLC or something like that. So we can talk more about that towards the Q&A. So again, last week we talked about kind of some of the terms that are involved in the term sheet, and this week we want to translate into what those look like for specific documents you'll see during the course of a venture capital financing deal. And really, there are many documents that are involved in a venture capital financing deal, but there are really kind of 5 core documents, and we're going to go through all of those today. And our goal is not that you come away with knowing all of the terms of every contract that goes into this, but just some kind of core principles that are associated with each type of document. Just to go back again to touch on what our colleagues talked about last week, we also wanted to just set the stage at a base level, have a takeaway of the idea behind common stock and the idea behind preferred stock. So common stock is what at the onset of your company you will authorize to later issue, and I'm sure Steve will get into that later. But as founders, that's what you'll hold in as far as ownership of the company goes, and some early employees may have that as well. Now, preferred stock, kind of a separate thing, and so that's something that the company will issue to investors in exchange for their participation and investment at different financing rounds. And so what is some of the core differences? Why is it called preferred stock versus common stock? Well, literally, the company through contract gives preferential treatment to the shareholders of preferred stock and investors that come in. And what's preferential about this? What is this kind of preferential treatment? Well, we'll go into a couple of these, but at a kind of a basic level, this could be something like liquidation preferences. So if there's some event, a change of control, a sale, or merger of the company, or if if the company sticks around long enough, a public offering, the preferred stock investors could get money back before anyone who holds common stock. So that's preferential. Preferred stockholders might get rights to dividends, and then there are a bunch of other potential rights that preferred shareholders can get. And we're gonna, as we work through the documents, one thing that I think we want you to leave with is an idea that, generally speaking, rights that are conferred in these preferred stock agreements and documents really are broken down into two classifications. One, economic rights, so financial payment related rights, and then governance rights, so voting rights and other kind of corporate control rights. Also, we wanted to provide this great resource for everybody. So there's an organization called the NVCA, the National Venture Capital Association. This is an industry group. It's led by VC firms and then some other industry professionals. So lawyers are involved, accountants are involved, companies are involved. And among one of the highlights and the great things about the NVCA is that as industry leaders and as an organization that sets the standard for the industries, they actually provide a lot of free resources, including form agreements. And so all of the agreements we go through today, you can actually look through, and you can go to this website, nvca.org, and see their model documents, which a great thing about those is they include drafting notes. So you can understand why things are written, what in a certain way, what might be important about certain provisions as you go through the agreements. And one thing we do want to mention, though, is that a lot of the NVCA documents, because the industry is VC led, some of the documents may have a slight slant that is more favorable towards investors. But again, this is why in any financing round, you want to work with a lawyer that you trust. So transitioning right into there, what is the lawyer's role in a venture capital financing round? So kind of first and foremost, we see the role of being a trusted advisor as of utmost importance. There are a lot of moving parts to venture capital financing deals, even as early as Series A, right? There are these long, complex documents. So the documents that we're going to look at today, one of these documents could be 30, 50 pages. And as you go through later and later stages and things get more complex and more parties come in, they get longer and longer. So you really want to have somebody who you trust, who can walk you through all of this and who has gone through it many, many times and understand why something is important. So in saying that a document could be 30 and 50 pages, between 30 and 50 pages, actually, in that 30 or 50 page document, there could be 3 or 4 provisions that are written in legalese that actually have a very practical meaning that you need to know and be aware of. So the role of trusted advisor, it's super important for lawyers involved in the process. And then document prep and filing, as I mentioned, there's a ton of moving parts here. So we'll go into that as we talk about the individual deal documents, but it's super helpful to have somebody kind of leading you through that process, and then also leading the due diligence process. And that's something that Steve will get to later on in the presentation, but you'll see why that's important moving forward. Okay, so to get into the deal documents themselves, and like I said, there's really 5 core deal documents that for a venture capital financing round for a Delaware corporation are often seen and kind of core to the process. So we'll take it into where they left off last week, and you're having a conversation with investors and it's going great, right? And so you're given a term sheet. And so before I start with the first document, I'm just going to show you a couple of snippets of one term sheet. So this is all going to be the same term sheet, and you're going to see some provisions that are involved, that are listed in the term sheet that will then, you'll see why they're very important, because they're going to actually create standalone documents that are involved with the financing. So here's a term sheet, and as we go through, note the provisions that are circled in red. So we have the charter, liquidation preferences, the voting agreement, drag-along rights, investors' rights agreement, demand registration, right of first refusal, co-sale. And so now we'll actually get into, remember those terms, we're going to get into where you'll see those terms across these different documents. So the first document, if you were paying attention just now, you would have seen the charter. So the first document is the COI, the Certificate of Incorporation. And I called out the charter because you will hear it either in discussions with lawyers or maybe VCs throughout this process. It'll be called the charter. So again, that mention from the term sheet is directly relevant to this. And so what is the Certificate of Incorporation? What is the charter? Well, it's basically the foundational document for the company. So before you even thought about raising outside financing, when you set up the company as a corporation in Delaware, you would have filed this document with the Secretary of State in Delaware, and it formally organizes and establishes the company. And so there's a lot of things that are listed in here that would make sense as being foundational to the company. So the name and the purpose of the company, the address of the registered office, very core things that we'll get back to later, like the number of shares of stock that the corporation is authorized to issue and the rights that are associated with these shares. And so I'll show you quickly, this is what that document would look like. We don't have to spend too much time on it because we're not going to delve into all of the words on the page anyway, just some basic core assumptions. But if you remember, the title of the previous slide was Amended and Restated Certificate of Incorporation. So what does that mean, and what's the difference between the quote unquote A&R Certificate of Incorporation and the regular Certificate of Incorporation? Well, during a venture capital financing round, in order to set forth the privileges associated with the preferred stock, the company's Certificate of Incorporation will literally be amended and restated once again to reflect these. So what does that mean practically? So practically speaking, when you first have the company incorporated, you don't have too many, you probably only have one class of stock, right? It's just common stock, and there are just kind of regular, easy to understand voting rights associated with that common stock. So once the company is originally founded, the Certificate of Incorporation, a much shorter document, maybe could be as short as a page or two, and more straightforward to understand. With each successive round of financing, this will get more complex, and as more preferred stockholders come in and there are different rights associated with those will all be reflected in the certificate, amended and restated certificate of incorporation. So in concert with that financing round, the company will have to amend and restate the certificate of incorporation. So that's the first deal document, the charter. The second document that we wanted to highlight is the voting agreement. So you may see it abbreviated as the VA. And so basically at the core, the voting agreement is really just an agreement to contractually bind certain shareholders to vote in certain ways. And so what this is, again, we won't get too detailed into the actual words on the page. We're just looking for kind of the general take homes, but this is what the voting agreement will look like. And so why is this important? So kind of one assumption and kind of guiding principle here is that when maybe early on in the company's life cycle, either pre-series seed or series seed, you may be looking at what's known as friends and family or individual angel investors. But when you start talking about raising a Series A round, a Series B round, later letters in the alphabet, you'll likely be you may be talking to institutional investors, VCs, and in raising a round, it is likely that you're not going to only raise money from one institutional investor, right? You open the round up to multiple investors, and you'll have what is known probably as a syndicate. So a number of investors who are going to put in different amounts, and within that syndicate, you'll likely have a lead investor, so a lead investor leading the round, right? And so the lead investor would put in the majority or above a 50% threshold of the investment for that round. In addition to that, that lead investor would likely handle communications between all of the investors and the company, and so this adds a bit of an administrative burden for that lead investor, right? So what does the lead investor get in exchange for taking on this administrative burden? Well, the lead investor may request some additional voting rights as the majority shareholder, the lead investor of the round, right? So in the voting agreement, actually, the company will negotiate with likely that lead investor for specific rights about if that lead investor makes certain decisions, whether or not that lead investor alone can uniformly make decisions that will cause the minority shareholders in that round and basically cause them to vote in the same way and force them to vote along with the interest of that majority shareholder. So that's kind of one idea, one guiding principle. Also, the voting agreement is important because it discusses things like the size of the board, and which will likely increase with additional directors that are associated with venture capital firms as with each successive round raise. So the third document that we wanted to address was the Investors' Rights Agreement, so the IRA, as you might see it. And what is the Investors' Rights Agreement? Basically, it's a collection of promises that the company makes to the preferred shareholders. And very quickly, this is what that would look like, the document itself. And so, like I was saying before, why is preferred stock preferred, and why is it preferential to investors? Well, this is a big reason, right? In the Investors' Rights Agreement, the rights that are promised to investors can be very important and can have real substantive and logistical impact on the company's operations. So what are some examples of rights that are conferred in the Investors' Rights Agreement? So one example, and this may be a little far down the line for companies that of your all's stage, but one example of a right that could be included in an Investors' Rights Agreement is what's called a registration right. And there's a type of kind of a flavor of a registration right, which is the demand registration right. And basically that at the core, that's the ability for investors to, if things are going well or they feel the company should go public, actually force the company to go undertake an IPO, which is, again, probably too far down the line to be thinking for all of us here today, but we just wanted to flag it as an example of a very powerful right that preferred shareholders can have over the company. More practically speaking, two examples of rights that might affect you all in the first couple of years of operation or years following venture capital financing rounds. Information rights. So what's an information right? So if anybody has seen, there's a show right now on Apple, I think it's Apple TV, about the the history of the last 10 years of the company WeWork. I think it's called We Crashed. And not to spoil the fun of the show, but during the show, if you've seen it, there's one episode where one of the venture capital venture capital firms that invested money in WeWork has issues with the way that the company is being run, and comes in and demands during a workday to see all of this information about WeWork's business. So all of these, they literally have to come in with binders and boxes full of documents. And so that's literally an example of information rights at play. So it's the right to come in and upon request, observe the books and records and observe a lot of logistical information about the company. What are observer rights? So as I mentioned before, in thinking about bringing on professional venture capital investment, one of the things to consider that is that once the round has closed, you should have the expectation that some venture capital firms will request to add members members to your board. So the size of your board of directors will increase, and the new directors that come on will venture capital investors will likely negotiate to have that new person be somebody that they elect. In absence of that, remember we said there are majority investors in the round, and there are the minority investors in the round. And some minority investors might also want to have individuals in the room at board meetings, but not necessarily have those individuals be on the board or have voting rights on the board. So observer rights are rights to put in somebody in the room that represents the VC and is privy to all of the conversations that go on during a board meeting, but don't necessarily get a vote. And there's a bunch of other rights. Covenants are basically just promises, and we don't, for the sake of time, we can skip going into too much detail for the moment. But the real big takeaway from the Investors' Rights Agreement is that it's really important to understand what you're promising to investors, what rights you're giving to investors, and then kind of a follow-up to that is that you should assume that anything you promise to an investor in an early round, those rights will carry on to investors in the later round, because when you have later round investors, the first thing they'll ask to you is, so what did you grant the folks in the last round? And likely they'll say, I want that amount of rights, those rights plus more. So just think about that these rights don't go away, and if you grant them to investors at one time, they'll probably live with along with the life cycle of your company. They'll live in later preferred shareholder financing rounds. So I think with that, I will. Oh no, sorry. Well, one more. So quickly, we talked about the fact that we have 5 kind of seminal documents here. This is not one of those 5 core documents. Not 100% of deals will have these, but we just wanted to raise this quickly to highlight the role of the lawyer in these financing rounds. So a legal opinion, this is what it looks like. at a very basic level, it is a letter that that your lawyers that are working with you will prepare, and basically will say, hey, we had the opportunity to delve deeply into this company. We looked at their capitalization table. We looked at all of the promises that they're making, and we feel confident that these are correct. And why is this important? Well, this allows the investors and the investors' counsel, the investors' attorneys, to rely on the information that you're providing. And then also, as we transition to later parts of this conversation, it'll address why there is such a need for your own attorneys to go in and do such thorough due diligence of your business throughout this process. So with that, I will hand things over to Ashley, who will talk about some other deal documents.
Okay, so our fourth deal document that we want to go over is called a stock purchase agreement. So a stock purchase agreement is a signed contract between two parties when shares of a company are to be bought or sold. So the stock purchase agreement includes important information such as the par value of the shares, which, in case you're unaware, the par value just refers to the value of a single common share as set by the corporation's charter. It also includes the number of shares that will be sold, and often it includes a right of first refusal provision, which I'm going to explain in further detail later in the presentation. So why is a stock purchase agreement important? Well, it's important for several reasons. One, it puts the terms of the sale into writing. Two, it provides specific information relating to the transfer of the stock. And lastly, it helps to avoid future disputes by eliminating potential disputes since the terms of the sale have been defined in writing to which the parties have agreed. Okay, so another key document is called the right of first refusal. So this provision provides non-selling shareholders with the right to accept or refuse an offer by a selling shareholder after the selling shareholder has solicited an offer for their shares from a third-party buyer. So this allows non-selling shareholders to control the process of adding a new shareholder while theoretically preserving liquidity for the shareholder. Unfortunately, it's important to note that this does run the risk of having the opposite effect, where the liquidity is actually impaired as a result of this provision discouraging offers. Okay, and wholesale rights. So these are commonly referred to as Tagalong rights. These typically arise in one of two ways. So first, they can be used to provide minority shareholders with the right to join in when the majority of shareholders or founders sell their stock. So this can provide some degree of protection for minority shareholders. Second, they can be used to provide a right for founders to join on to a sale by investors. So why are wholesale rights important? Well, for one, they allow smaller shareholders the ability to take part in some of the better deals that typically are only afforded to larger shareholders. They also help to deter deals that would require investors to exercise these rights. So just by including this provision, it can serve its intended purpose in some cases without even needing to exercise it. Additionally, it allows investors an out should all of a company's founders start selling. Okay, so now that we have wrapped up some of the key deal documents, I'm going to provide a brief overview of some general key securities laws. So to start off with the basics, a stock is simply a security. As such, securities laws must be complied with in connection with the term sheet sale. So securities are regulated by both federal and state government. State securities laws are also commonly referred to as blue sky laws. So it's really important to pay close attention to these as they can vary greatly from state to state. Further, blue sky laws can sometimes preempt federal laws. So again, very, very important to pay attention to these. Both federal and state laws regarding securities require that in connection with an offering of securities, the securities must be registered. This is generally a time-consuming and expensive process. However, in order to avoid the time-consuming and expensive process of registering securities, a company can file an exemption from registration. So before I get into a general overview of some of the most commonly used exemptions for startups, I want to go over a couple of key terms in connection with the exemptions that you may not be familiar with. So first, the term accredited investor is a common requirement in some of these exemptions. So first, the term accredited investor, an accredited investor is just an individual or entity that meets the requirements in order to trade securities that may not be registered with financial authorities. The SEC has financial requirements for an individual investor to be considered accredited. An individual or married couple must have a net worth of at least $1 million, and that has to exclude the value of their primary residence. Or if the individual does not meet the net worth criteria, then they can be considered an accredited investor if they have a minimum annual income of $200,000. They must have had this income for at least 2 years prior, and there should be a reasonable belief that this income will continue in the future. Also, if married and filing jointly, to be considered an accredited investor, the couple must have a combined income of at least $300,000 for the prior 2 years, and also have a reasonable belief that this income will continue in the future. Also, another important term to note is general solicitation. So this refers to the act of marketing a capital raised publicly or the advertising of the sale of securities to the public. Okay, so now that I've gone over a couple of the key terms, I'm going to provide a very general overview of some of the most common exemptions. So first, there is the private placement exemption, section 4A2. So this exemption does not require that investors are accredited. It allows for a company to raise unlimited funds. However, it places a ban on general solicitations, preventing a company from marketing or advertising their offering. Next, there is the Regulation D exemption for Rule 506B. So this exemption allows for up to 35 non-accredited investors to participate in the offering and an unlimited number of accredited investors. However, non-accredited investors or their purchase representative must meet the legal standard of having sufficient knowledge and experience in financial and business matters to be capable of evaluating the merits and risks of the prospective investment. It allows for the company to raise an unlimited amount of funds, and like Section 4A2, it prohibits the advertisement of the offering. Similar to Rule 506B, there is Rule 506C. So this exemption requires that all investors are accredited investors. So unlike 506B, it does not allow for a maximum of 35 unaccredited investors. Similarly, though, it also provides for the raising of unlimited funds in the offering. Lastly, this exemption actually allows for general solicitation. This really is a key difference between 506B and 506C. However, in order for general solicitation to be allowed, the issuer must take reasonable steps to ensure that all investors meet the accredited investor status. And lastly, we have the Massachusetts crowdfunding exemption, which is somewhat recent. So this exemption does not require that investors meet the accredited investor status. And unlike the other exemptions we covered, this exemption does cap the amount of capital that can be raised. So it limits the funds to a cap of $1 million in a single year, unless the company provides audited financial statements to all potential investors, in which case then the cap increases to $2 million in a single year. Additionally, this exemption allows for advertising of the offering. Okay, so now that I've wrapped up our securities law overview, I'm going to turn it over to my partner, Steve, who's going to provide information on the due diligence process.
All right, thanks, Ashley. So taking a step back, Ben talked about how the term sheet gets translated into the 5 key deal documents, and Ashley talked about securities law exemptions that you'll need to comply with to avoid registration of your offering. The third major component of a venture capital financing deal is due diligence. So I'm going to talk through what due diligence is, when it happens, why we do due diligence, and who's involved. So first of all, what is due diligence? A common analogy used to describe due diligence is when you buy a used car. So if you're going to go buy a used car from someone, before actually handing over the cash and signing over all the paperwork, you're going to want to have your mechanic look at the car and make sure that there's no problems with it before you buy it. And if there are problems, you might adjust the price of the car, or you might drop the sale of the car altogether. It's similar to with an investment in a company. So before a venture capital firm invests in a business, they're going to conduct due diligence to ensure that there are no issues with the company that they need to know about. So this is going to involve the inspection of corporate records, including the certificate of incorporation, board minutes, IP documents, the review of important contracts. And this is all done to make sure that there are no issues with the company that the investors are unaware of. So when does due diligence occur? Like I said before, due diligence occurs after the term sheet is signed, but before the conclusion of the investment deal, before anything is signed. So doing it at this stage, there's already a framework for the deal in place, but it's not signed yet. So there's still wiggle room if terms need to be adjusted or things need to be resolved. And why do we do due diligence? As I've already said, this is to identify and resolve issues prior to the closing. When issues are identified, they can either be resolved and then done away with, or it might be something that can't be easily resolved. And then that would result in having to change the terms of the deal, whether that be price or certain risk allocation provisions within the deal documents. And then also who is involved. You're going to have lawyers on both sides. Counsel for the venture capital firm is going to be conducting due diligence as a way to identify problems that could put their investment at risk, but the lawyers for the startup are also going to be doing due diligence. And part of that is related to the legal opinion, which Ben spoke about earlier. Your own lawyers need to have a thorough understanding of the documents for your company, because they will be issuing opinion as to their validity and as to their what they say. The founders are also going to be involved in due diligence because not only is an investment in an idea in a company, but venture capital investors are going to be looking at you as founders to make sure that you guys are people that they want to invest in. The investor is going to be involved, obviously, and then third-party advisors. So you might have accountants that are dealing with financial statements. You might have consultants that are doing research into your product or into the market space. And there are two types of due diligence. There are legal due diligence and there's business due diligence. Today, we're focusing primarily on legal due diligence, which involves corporate governance documents, board minutes, the equity structure of the company. So they're going to want to see a cap table that lists out who the owners are and how much stock they own. The material agreements, so any important supplier agreements, customer agreements, employment agreements, IP ownership, and then also pending litigation. So an investor would want to know if there are any legal claims being made against the company or potential claims that could involve loss. And then business due diligence is looking at financial statements, looking into the founders, and then doing a deep dive into the market that the startup's in and also their specific product to make sure it's something that can make money down the road. On this slide, I have a timeline of where due diligence fits into the rest of the deal process. So first you have the term sheet, and then once the term sheet and framework for a deal is in place, due diligence begins. And that typically starts with the investor's lawyers sending over a request list of all the documents that they want to see and all the questions that they have for the startup. From there, the startup will work with their attorneys to upload all the required documents into the data room, which is just an online portal that's secure and safe that only the people who are relevant to the deal have access to. And from there, both sides will do a deep dive into all the data and documentation within the data room and come up with any open issues or open questions that need to be resolved. From there, they will resolve those questions, which at times can bleed into the negotiations because if any of those open issues result in further negotiations, then you're going to continue negotiating until the deal is ultimately closed and everything is resolved. Now, what are some common questions that startups will be asked during due diligence? One of them is whether they've had outside employment other than the startup during the course of their relationship with the startup. So if you started a company while you were an undergrad or a graduate student, but you were simultaneously working for another technology company or you're doing an internship over the summer, they're going to want to know first of all, if you had other employment relationships, and second of all, if you did, they're going to want to see the employment agreement for those relationships. And the reason for this is that anything that you signed during simultaneously with working for the startup, there could be issues surrounding the ownership of IP that was created during that period. So the answers to those questions would be found in your employment agreements. And if you had an employment agreement with a tech company that was in a very similar industry to your startup, it's possible that there was a provision in there that basically says that any IP relevant to that business created during that time is assigned to the company you interned for rather than the company that you founded. It's not always an issue, but it's an issue that needs to be identified early on so it can be resolved. Another common question is, are you in compliance with laws and regulations that are relevant to your industry? So if you're like a health product, have you complied with FDA approvals and requirements? If you're a food service business, have you complied with municipal permitting and health regulations? And then also you're going to be asked about competitors in your industry, because venture capital firms are going to want to know that you have a thorough understanding of the space that you're in and the market that you're competing with. Now I'll talk about some common requests. So like I've mentioned before, the corporate governance document. So this is going to include your certificate of incorporation that says where you're incorporated, how many shares are authorized, also the bylaws. They're going to want to see board minutes because the board minutes show the actions and decisions that were authorized by the board. Another request is employment agreements, and that leads me back to what I was talking about before with those IP provisions that are important. And then also customer and supplier agreements, because they're going to want to see what relationships you have with third parties and what the terms of those relationships are from a business and a legal standpoint. And also financial statements. If you are if you're far enough along in the process of being a startup and you've been conducting business and you've had expenses, or maybe you've even had revenue, they're going to want to see those numbers as well. So now I'll discuss some common issues that occur during due diligence. The first category of which is questions surrounding IP ownership, which I've already touched on a little bit. So the first point I want to talk about is when you have a startup and the intellectual property and the idea that that your product is based on, if it was developed using school resources or in conjunction with research that you're doing at either MIT or BU, it's important to talk to your respective school's technology licensing office, because the way the law works is if you're using resources from the school to develop a product, to develop intellectual property, it's likely that the school will have a claim to own that intellectual property. So by talking with your respective school's technology licensing office, first of all, you'll be able to sort out who owns the IP. And second of all, if the school does own the IP, then you can work out a licensing arrangement where you would pay a small royalty to the schools, depending on how that got negotiated, in return for being able to use the intellectual property. Another IP issue is when there are prior founders who are no longer with the startup. And issues can arise there when you might have had at a very early stage, even the first few months of a startup, there was a founder involved who contributed some ideas and contributed ideas that are considered intellectual property to the business. And then maybe a few months later, they decided that they didn't have the time or they didn't have the desire to continue moving forward with the project. When they left, you need to make sure that any IP that was developed by them and contributed to the company actually was legally and appropriately assigned to the company. That can be accomplished through the appropriate IP assignment documents, which our Startup Law Clinic drafts all the time for our clients. Those are technology assignment agreements and also proprietary information and invention assignment agreements. And then the last issue with IP ownership is outside employment, which I discussed in the last slide. Another category of issues also involves ex-founders, but rather than issues of IP ownership, there can also be issues of actual equity ownership and having a piece of the pie. So when a founder leaves, you want to make sure that you've documented everything appropriately. So you want to make sure that you document the resignation. The resignation typically needs to be acknowledged by the board. And then also, if that founder has been issued shares, you need to have the proper the proper documents that basically say how many shares the founder is walking away with, or whether some or all of those shares are being redeemed and given back to the company. If that's not handled when it happens, and down the road that founder comes out of nowhere and says, hey, wait a minute, now that this startup's worth so much money, like I was involved in this, like where's my cut? That actually happened several years ago with Snapchat. There was a founder who was involved during the first few months of the startup, and years down the road, he sued the company and ended up with a multi-million-dollar settlement. So that's something that needs to be avoided, and it's avoided by having the proper legal documentation early on. Now, another category is having not having enough shares, and that's because if you've authorized shares and you've issued all of them already, you wouldn't have enough shares to dole out to investors. That can be worked around by just authorizing more shares, but it's something that's just more costly, more time consuming, and can be easily avoided. So when you do form your corporation, talk to your attorneys, tell them about what your goals are for the future, and they will advise you on the proper number of shares to authorize and also the right number of shares to issue upfront. So lastly, I'll talk briefly about how you can prepare for due diligence before you get to it. That way you're ready when investment does come and you're ready to sign a deal. The first is forming a Delaware corporation and using an attorney specifically. Ben talked earlier about how the presumptions of this presentation are having a Delaware corporation. And we don't want to scare anyone who has a corporation in a different state or someone who has an LLC, because those entities can be converted to a Delaware corporation. The reason we say Delaware corporation is because the vast majority of venture capital firms prefer to invest in those entities. And we can explain why if you have questions later on. But I just don't want anyone to panic if they don't have that right now and they want to have investment in the future, because you can work with your attorney to convert it over to the proper entity. But the key here is when you do form whatever entity you choose, when you start your company, you want to use an attorney, because having an attorney walk you through this process will make sure that you have all the appropriate documents that you need to draft to form the company, and then also the post-formation documents, which would be the stock issuance and the appropriate technology assignment agreements that I talked about earlier. Because doing these things the right way the first time will not only save you time and money down the road, but you'll also be glad once you get to due diligence because you don't have to worry about it. Second is authorizing enough shares. You're going to want to make sure that you authorize enough shares, not just for your founders at the outset of the company, but also for any potential investors or employees down the road who will be issued stock. Thirdly, you're going to want to read your employment agreements. So if you have a startup that's maybe it's on the back burner for the summer and you're going to be working elsewhere for a few months, make sure you read your employment agreement to identify any provisions that could put any intellectual property at risk that you will be developing for your startup during the same time that you were employed elsewhere. Next, you want to document and keep board minutes. If you're a corporation, there's certain formalities you have to comply with. One of those is having board meetings and authorizing major actions of the company. So as you go through the company life cycle and you're making decisions, just make sure those decisions are documented in the board minutes and saved somewhere, so that once due diligence does happen, they're all in one place and can be easily provided to your lawyers. And this leads right into the next point, which is keep the records organized. Leave a paper trail for everything, have contracts in writing, keep a cap table to document ownership, and then also keep financial statements and financial data organized, because down the road, you'll be glad you did. Next, I just want to say, look in the mirror. Venture capital firms, like I said before, aren't just focused on the business, they're focused on the founders as well. So part of due diligence will be looking into the founder's background. So just make sure that the way you present yourself publicly does not reflect poorly on you. And then lastly, conducting internal due diligence is also a way to prepare, because that allows you to identify issues before investors do and address things head on early on, rather than causing delay when you're at a late stage of the deal. So that wraps up our presentation. Now I'm just going to talk about the key takeaways briefly. If there's nothing else you take away from this, these are the main points we want everyone to remember. The first is with deal documents, Ben's portion of the presentation. The key things to know there are just to know that there's a distinction between common and preferred stock, and that preferred stock can provide significant advantages to investors. So make sure when you're going through the deal process, you're agreeing to a term sheet and you're drafting, when your lawyers are drafting the documents, make sure that you're just understanding what rights you're giving to investors, because that's going to have the biggest impact on you, other than there's going to be pages and pages of deal documents. There's going to be a few sets of provisions that really do have an impact on how your business will be run and what say you have in the business going forward. The next is with securities laws. Just make sure you use and comply with an exemption. As a startup, you're not going to want to register securities most likely. So talk to your lawyer and figure out which exemption you best fit into and how you can comply with it. And then with due diligence, talk to lawyers early and often and keep things organized. I just went through everything you can do to prepare for due diligence, and just make sure you stick to those steps and you should be okay. And now we'll open the floor to questions. I know there's some in the chat, but if anyone wants to raise their hand and speak up, you can also do that. So the first question in the chat is, will the slides be emailed like in part 1? I believe they'll be posted to the Startup Clinic's website along with the recording. Jim, I don't know if you emailed for the last presentation. Is that something we're also doing?
Yeah, I'm going to put an email in the chat, and if somebody wants them emailed, they can send an email to this address, and we'll take care of that.
Okay. So that email is in the chat. Just email the startup@bu.edu if you want to request the slides. Next question is, when founding the company and establishing the charter, how do you usually establish the number of shares of common stock issued in the beginning? What's the typical number of shares issued in the certificate of incorporation for a tech startup? So this question, Ben, do you want to take it, or?
Yeah, sure.
Okay.
That's no problem. So generally speaking, the way you establish the number of shares is through a board action. And so the board will authorize a certain amount of shares, and that will be reflected in the certificate of incorporation. So as far as the second part of the question, what are the number of shares usually authorized? So this is I mean, I should give you the lawyer answer at the beginning, which is that this is case specific, and that these factors can affect investment decisions and bringing on investors and the growth of your company. The number that for a Delaware corporation, like let's call it a tech startup, that lawyers and other people in the space like to throw around is 10 million. But again, really that number, before you authorize that number, you really should sit down with an attorney and go through goals for growth for the company. And growth doesn't mean just venture capital financing. It also means how many people you want to bring on and kind of the nature of your business. So, all right. Well, do we have any other questions? Feel free to shout out or raise them in the chat. Oh, nope. Okay. All right. Well, if somebody's typing, feel free to shout out now. But in absence of that, I think I will just thank you all for joining. Thank again Steve, Ashley, and Jim. And other than that, have a great weekend. And we look forward to hearing and seeing you around the Startup Clinic.